Hello, my name is Melanie Tuttle. I'm a lawyer practicing employment law in Greensboro, North Carolina, and it's now December, which for many employers means it's the holidays and parties. Let's talk about some of the issues we'll need to think about for our holiday season. First, let's discuss religion and the holidays. Employers must be aware of and avoid religious discrimination in the workplace. Discrimination might become evident in holiday displays and decorations and how an employer responds to requests for time off. Title VII of the Civil Rights Act prohibits employment discrimination based on an individual's religious observances, practices, or beliefs. Religious beliefs are sincerely held moral or ethical beliefs as to what is right and wrong and have the strength of traditional religious views. Beliefs, practices, and observances are protected. So who could be offended by a nativity scene in the office lobby in December? After all, it's Christmas. That's not the right question. All religious beliefs are protected, not only those held by the majority in a particular workplace. So what's an employer to do when employees get in that festive spirit? First, they may permit and include all manner of religious displays, such as a creche, a menorah, a Christmas tree, Santa Claus. Or they may choose to not permit any displays. That way they're not playing any favorites, and no one can claim religious discrimination. The third option is to use only secular decorations, such as snowflakes and snowmen. Another area in which employers confront religious issues at the holidays is accommodating requests for time off. As a general rule, employers are required to reasonably accommodate an employee's request for time off for religious observance, unless it would cause an undue hardship for the employer. The two key concepts here are accommodations being reasonable and whether the hardship imposed on the employer is undue. And whether an accommodation is reasonable or a hardship is undue is assessed on a case-by-case basis. Certain accommodations that are considered reasonable and that an employer may want to consider include floating holidays, swapped holidays, flexible scheduling, allowing voluntary substitutions of assignments, permitting employees to work through lunch hours in exchange for leaving early or arriving late, offering staggered work hours, allowing employees to make up hours by working longer shifts, or providing unpaid leave. So what is an undue hardship for an employer? It's undue if the accommodation would impose more than a small cost or cause more than a minor disruption to the employer's operations. So when we're responding to a request for accommodation, note that the religious practice must be based on a sincerely held religious belief. Employers may consider whether attendance is required by the tenets and beliefs of the particular religion, and employers may request verification of attendance, such as a church bulletin or other evidence of participation. The other area in which employers have issues in the holidays is the office party. Now, let's plan our party. Like any other party, let's discuss who, what, when, where, why, and how. But before we get there, let's realize there are three primary issues that are going to confront employers: harassment, intoxicated employees, and workers' compensation. Harassment is a very big issue for employers because the office party is often viewed by some as the opportunity to suspend all rules of decent conduct. There are sexual innuendos and jokes, overt sexual acts, and gifts of a sexual nature. So what do you do to minimize your risk of sexual harassment? Recirculate your harassment policy before the party. Consider adopting a specific policy regarding employer-sponsored social events as a supplement to your harassment policy, and include specific examples of unacceptable behavior. Enforce your dress code at the party. Consider allowing employees to bring guests. It's less likely that an employer is going to act out if his wife's at the party as well. And eliminate or reduce alcohol consumption. And remember, not all harassment is sexual. There can be harassment based on race, age, religion, any protected class. Of course, parties oftentimes bring alcohol, and this relates to risks for the employer. Note that an employer may be liable for negligence if it served alcohol to a person when it knew or should have known the person was intoxicated and when it knew the person would be driving afterwards. This negligence liability is called social host liability. Social host liability is not strict liability. The standard is whether the employer knew or should have known the employee or guest was intoxicated at the time he or she was served. Employers can be liable a different way with respect to the actions of their employees. This is called respondeat superior. In this case, the employer may be held vicariously liable for the negligence of its employee, who becomes intoxicated at the employer's sponsored function. The employer will be liable if the employee is negligent while acting in the course of his or her employment, and that negligence causes injury to another, even though the employer himself was not negligent. So the real question here was whether the employee was acting in the course of his or her employment. The factors to consider are whether the employee performed any of his or her job functions while attending the event. Did the event do more for the employer than simply boost morale and camaraderie among employees? And did the event result in a specific benefit to the productivity or profitability of the employer's business? Also, was the event held during normal business hours? Was the event held at the employer's place of business or some other facility? Were the employees paid for the time spent attending the event? Was an employee required to work if he chose not to attend the event? Did the employee feel compelled to attend the event? Would failure to attend result in adverse consequences for the employee? Was attendance taken? Was attendance even required? An employer must keep in mind that an employee need not even be intoxicated to negligently inflict injury on another, and respondeat superior may still result in liability to the employer even when there's no alcohol involved. So how does an employer minimize the risk of intoxicated employees? 1, don't serve alcohol at all. Hold the event at a restaurant or other place where professional caterers and bartenders serve the alcohol. Avoid serving alcoholic punch or other beverages that mask alcoholic content. Have adequate supervision. And if the event is on site, hire independent caterers and instruct them not to serve anyone who appears intoxicated. You should also check your general liability policies for any alcohol-related exclusion. Determine the scope of your coverage and obtain a special events policy to cover the event if necessary. Communicate a tone of moderation before the event. Remind employees that intoxication violates company policy. Arrange for free transportation or a safe driver system, and devise a method to limit the amount of alcohol served, such as issuing drink vouchers or limiting the time the bar is open. You can also avoid hard liquor and serve only beer, wine, and non-alcoholic beverages, and provide entertainment as a diversion in drinking, and serve foods that slow alcohol absorption, such as starches and protein, and avoid serving salty or greasy foods. Workers' compensation also rears its head during the holiday times. I'm sure you've all been at parties where someone falls to the floor while doing the electric slide. In North Carolina, a court has awarded workers' compensation benefits to an employee for an injury to her ankle she sustained while dancing at her employer's Christmas party. So you'll need to keep that in mind. Employees injured during an employer-sponsored event may be entitled to workers' compensation benefits if their injury arose out of and in the course of employment. The factors in determining whether an injury arose out of and in the course of employment are very similar to those we discussed earlier with regard to respondeat superior. Did the employer sponsor the event? Was attendance really voluntary? Was there some degree of encouragement to attend the event? Was attendance taken? Was the employee paid for attending? Was the employee required to work if she did not attend? Did the employer maintain a custom of attending? Did the employer finance the event to a substantial extent? And did the employees view the event as an employment benefit to which they were entitled as of right? The employer benefit from the event not merely in a vague way through better morale and goodwill, but through tangible advantages such as the opportunity to make speeches and give awards. To minimize the risk, implement the same precautions as those we discussed earlier to reduce the risks of intoxicated employees. Emphasize that attendance is purely voluntary. Emphasize that the event is purely social. Do not invite customers or clients. Leave it up to the employees to organize and finance the party on their own, off premises. So let's go back to our party invitation. We've talked about who, what, when, where, how, and why. Keep these in mind as you plan your holiday parties. And remember, too, if you have any problems, any mishaps, be prepared to conduct an investigation immediately and take care of those issues. Happy holidays.